I'm now going to call Ms. Janine Myburg, who's the chairperson of the Legal Practice Council, to give us a message of support. Janine, I don't know if you want me to go through your bio, but no, okay, she's saying no. We know Janine, we know your accomplishments, and welcome. Thank you so much.
I see it's exactly 2 minutes before 12, so it's still good morning, ladies and gentlemen. Madam President Eunice Masipa, Deputy President Joanne Anthony Gooden, other Deputy President Ramagaga Mutseku, I saw her earlier, the LSSA CEO, members of the Department of Justice, and specifically the DG Advocate Doc Mashabane, members of the judiciary. I don't know if the KZN JP is present. In their absence, Judge Tlewati, the master or the representative of the master of the High Court, my very favorite legal services ombud, Judge Desai, and his staff, the chairperson of the Legal Practitioners Fidelity Fund, Ms. Kakana, the CEO, Mr. Molefe, members of the National Council and Provincial Council President, unlike your HOC members, my LPC Council members are all stuck in the back in the corner, if you were looking for them. All leadership, management, and members of the LSSA, members of the profession, ladies and gentlemen. On this occasion of the annual general meeting, I want to commence my address by conveying my appreciation to the LSSA for your continued contributions to advancing the legal profession and advocating for legal practitioners. At the LPC, we acknowledge you as a key stakeholder in the legal profession. We appreciate your views, inputs, and engagements at all times. I have no doubt that the legal profession would not be advancing as it has been had it not been for our stakeholders. To quote Helen Keller, who said, "Alone we can do so little, together we can do so much." Saying this, I am by no means indicating that we are to agree on everything. Robust debate is healthy and often required to achieve the desired outcome. It is imperative for me at this juncture to stress that the role of the LPC as the regulatory body and the role of the LSSA differs. Yet I believe that we must work together where required for the betterment of the profession. It is at times regretful to see that many a practitioner has yet fully to grasp the role and the objectives of the Legal Practice Council. Specifically, the objectives of the LPA as articulated in Section 5. Every action of the LPC is guided thereby to realize and maintain the 12 objects of the LPA. It seems to me that the role of the LPC is more critical today than ever. Of the challenges we continue to grapple with is ensuring that we are strong and effective in achieving our key objectives of the LPA as envisaged, which includes, amongst others, protecting the members of the public, being an independent regulator that enables and facilitates efficient functioning of the legal profession, facilitating access to the profession and to justice, upholding the independence of the profession, maintaining the integrity and the status of the profession. As a profession, we face many an uphill battle, or as Tata Madiba said, after climbing great hills, one only finds that there are many more hills to climb. I believe it to be true that the existence of the LPC imitates life. The last 5.5 years in the existence of the LPC, it can at best be described as being challenging, complex, demanding, yet most exciting. Being a member of both councils, whose first tenure was from 2018 to 2021, and now as chairperson of the second council, I'm privy to the fact that there was extensive groundwork done and work continues to be done by the LPC Council and the staff to ensure that we adhere to our mandate in terms of the LPA. The LPC continues to go about the business of ensuring that our structures and processes are in place while striving to actively improve the efficiency of attending to the work we are required to do. Depending on who you talk to in this measured approach has been interpreted as the LPC being toothless and not dealing decisively with cases of misconduct against legal practitioners. Often criticism by high-profile individuals in the media has the tendency to focus on a handful of challenging matters we are dealing with. This is then used as the barometer to measure the overall performance of the LPC. We find that such criticism often fails to interrogate the whole picture of the overall outcome of the work done by the LPC. As an example, there may be a handful of cases in the media that you are aware of regarding misappropriation of trust funds. At any given time, this usually does not acknowledge that and I'm giving you 2023 as the example, that in 2023, there was the striking of 251 legal practitioners and the suspension of 362 legal practitioners. Last year, we received 14,880 new complaints and finalized historical complaints to the tune of 14,377 complaints. Including the new complaints received currently, we have 22,000 pending complaints against legal practitioners. Ladies and gentlemen, none of these figures are anything to be proud of. As a profession, such a number of complaints against members of the profession must give us all cause for concern. At the LPC, we note the challenges of a lack of appropriate ethical conduct of some legal practitioners. We are also seeing that there are way too many legal practitioners that are on the wrong side of the ethical divide. As a legal practitioner, one's integrity and ethical conduct must at all times be top of mind. The lack thereof is often at the heart of the complaints we receive, especially complaints regarding the misappropriation of trust funds. It is imperative that all legal practitioners conduct themselves ethically, with integrity, and at all times acting with decorum. It pains me when we have to apply for the suspension or the striking off of legal practitioners. Believe me, these decisions such as these are never taken lightly. As members of the Council, we are painfully aware that legal practitioners spend many years working to qualify and to be admitted as legal practitioners. In this context, it is particularly important that we place a strong emphasis on the legal practitioners adhering to the code of conduct. It goes without saying, access to the profession and the true and actual transformation of the profession in line with the demographics of the country is paramount to the Council, who actively drives the realization hereof. Briefly touching on a few items that the LPC is currently engaged in. The LPC is engaged in the finalization of the issue of minimum remuneration for candidate legal practitioners. As you all know, we asked for comments, none were received until we gazetted it, and then we were inundated with comments. We've taken all the comments seriously to such an extent that we are consulting or working on it further, in that we know that, for example, a firm in the far-flung areas of Free State cannot necessarily afford the same amount to pay as a firm in Sandton. Ladies and gentlemen, I want you to please be assured that each and every decision taken by the LPC, including the funding, is at all times thoroughly ventilated and debated to ensure that the outcome is in line with the objectives of the Council and the best interest of the public as well as the profession. Yesterday, you would have received the LPC draft guidelines on community service and pro bono work for candidate and legal practitioners. Your input and suggestions and comments are required by 20 May. I urge each and every practitioner to be a willing participant in your very own future. These guidelines affect each and every one of us. This is your opportunity to be heard. Once all of the comments and responses have been considered, the final guidelines will be published and implemented. The more burning question for senior practitioners seems to be the issue of senior status being granted to attorneys. The LPC is currently seized with the matter and dealing with the practicalities and implementation thereof. There are some challenges that need to be overcome, and regarding interpretation and clarity on these guidelines is being sought. The profession will be advised in due course of the process and the date to submit your application. I assure you that we are aware of the urgency and we are dealing with it as practically and as speedily as we can. I looked at my address, and this ties to what was said earlier last year to compare what I was saying today, in case I'm not saying the same thing. But I saw that the issues of the amendment to Section 25 that deals with the proposed extension of the right of appearance of candidate attorneys beyond the expiry of their practical vocational training contract is still pending. I personally have been in contact with the Minister of Justice. I met with the Deputy Minister of Justice. I met with the Minister's advisor. I know there were discussions at the Portfolio Committee. Regrettably, this amendment could not be passed. We've been trying at the LPC for the last 4.5 years. My predecessor started writing to the Minister on that. I followed up, and we were informed that no amendments can be made before the elections. I have been informed that after the election, this specific amendment, because it's close to my heart, will be affected. The LPC is also engaging with other regulators to ensure compliance intelligence, such as the FIC and SARS. All legal practitioners are requested to ensure compliance with their statutory obligations to avoid penalties and sanctions. No doubt, many of you on Valentine's Day received heartfelt messages and calls celebrating Valentine's Day. Not me. I got repeated WhatsApps of the article that came out that said that estate agents and legal practitioners are the reason that we as a country are not getting off the grey list. As a former leader of organised business, I can't express the seriousness of a country being on the grey list. I therefore beseech each and every one of you to ensure that you are compliant. Regarding the competency-based examinations for candidate attorneys that were recently completed last month, the LPC has established a nationally marking centre where all examinations throughout the country will be marked in one central location. This ensures that a high standard is maintained while ensuring uniformity, consistency, transparency of the marketing process. We listen to your comments regarding the exams. I have absolutely no doubt that there are many matters or questions that you would have wanted me to raise, but due to the time limits, I have to restrict my comments. I can, however, as a profession, tell you that we are on a strong trajectory to ensure proper regulation of the profession. Currently, as of 1 April this year, we have 33,190 practicing attorneys, 32,087 non-practicing attorneys, 964 practicing advocates, and 1,854 non-practicing advocates enrolled by the Council. We continue with our efforts to ensure that the role is kept up to date, and as new legal practitioners join the profession or those who cease to practice. I wish to extend my gratitude to the judiciary for continuously ensuring that legal practitioners appearing in their courts are all registered with the Council, and I urge each of you to notify your provincial office and update your contact details should your address or status change. I want to reiterate, the LPC is mandated to protect the public interest, to regulate all practitioners and candidate legal practitioners. We will continue to improve, review our processes to ensure that we are able to meet the goal of protecting the public and uplifting the profession. We have a need your cooperation for this. I'm indeed honoured to stand here today formally to convey a message of support to the LSSA on behalf of the LPC, which I wholeheartedly do. I am, however, here today to ask you for your cooperation as legal practitioners to assist us with the gargantuan and ever-evolving task of regulating our profession in the interest of the public by asking you to adhere strictly to the Code of Conduct. Regarding the comments made by the President of the funding, we have met. We are both in agreement that it was a good meeting. We are still awaiting the annual financial statements that was just approved now to consider, and we are still awaiting questions on the reserves, because as you would have heard, the LPC also had to deplete its reserves. I also want to stress it is not as if the fund says, here's X amount and pay it over to the LSSA. The LSSA is one of our service providers. We have to do a lot of processes before we allocate the funding. But as I have indicated, no decision is made without it being thoroughly debated, ventilated. And we have indicated after the meeting on Monday, should there be relevant information that is coming forward from the LSSA, I will personally take it to my council to deal with. I sincerely thank you for your time and attention, and I look forward to the deliberations further today. Thank you.
Thank you so much, Janine, for taking the profession into confidence regarding what the LPC has been doing. And I also appreciate that you clearly distinguished the different functions of, or the difference between the LSSA and the LPC with regards to their functions. But I also just want to say, when it comes to issues of ethics, I would encourage the LPC not to spare the rod, because we are supposed to be a profession that is noble, a profession that is disciplined. Thank you so much for the message of support. The next speaker is the Judge President of the Gauteng. My apologies. My apologies, because the last time I saw her in Gauteng, so. But Judge Poyotlwat, who's the Judge President of KZN. And ladies and gentlemen, she is the first female Judge President that was appointed by our President Cyril Ramaphosa. Can we applaud that? And to also note that the JP is a former co-chair of the Law Society of South Africa. And previously we used to call the vice presidents or the presidents co-chairs. So in essence, she is a lifetime president of the Law Society of South Africa. JP, you are welcome, and thank you for honoring us with your presence.
Thank you for that warm introduction, President. I am truly indebted. When I walked in, you all sat down, and I thought you were going to rise. So I am quite disappointed. I will take it that I will attribute it to two things. One, because I'm youngish. Two, because I'm female. And probably three, because I'm black. But because we are in KwaZulu-Natal, the kingdom, I forgive you. Also, when I came in, Mr. Trikamji was on the podium, and at some point, Mr. Krish Govender was seconding. I thought, oh my word, old, same, old, same, old, same. Some things never change. The more they change, the more they remain the same. But thank you, President, and your team for inviting me It's a great honor and privilege for me to be here today. And I stand by all the protocol that has been observed. But in particular, let me welcome to the kingdom the retired. So he was tired, but he became retired. Judge Siraj Desai to KwaZulu-Natal, we welcome you. And we also welcome the DG of the Department of Justice to the province. They ought to have announced their arrival. So there are a lot of disciplinary issues that I have to deal with, even in the retired colleagues. I wasn't sure what to speak about today, because I'm not a person that likes to stick to script. And I have been found wanting for that reason, because after every occasion they ask for my speech and I'm like, I don't really have, I was just talking from the heart. So I can ask you to just try to record if you can, because some of the things I'm going to say are not in my speech. The reason why they're not in my speech is because they're very basic. I thought I want to take you back to basics, because there are a few things that we take for granted. There are a few things that we disregard as professionals. But the attorney's profession is very important in the country and elsewhere. Did you hear me? Attorney's profession. I haven't said advocate. Sorry, Advocate Mayberg. The Chief Justice of this country was an attorney. The President of the Supreme Court of Appeal was an attorney. I was an attorney. The Judge President of Umhlanga Division of the High Court was an attorney. The Judge President of the Competition Appeal Court, Judge Norman Manoim, was an attorney. The Judge President of the Northern Cape was an attorney. Do you still want me to continue? The Judge President of the Free State, and I will end there, you can do the rest of the research, was an attorney. So the majority of the heads of courts of this country were attorneys. That is because there are certain particular special skills that I believe we possess as attorneys. Those include, but not limited to, the integrity that we ought to have, the discipline that we ought to have, the collegiality and respect that we ought to have, the management skills that we ought to have, and the list goes on. So it really saddens me today when at times you go to court and you see a very lack of respect in the courts. You see people are not properly dressed before judges, before magistrates. People talk back, whether you are a JP or a judge or a magistrate. It never used to be like that. Sorry, I'm sounding very old, but it never used to be like that. You ought to respect, because the duty owed by a legal practitioner to the court has been summarized by Lord Reed in the English judgment of Rondell versus Wesley as follows. As an officer of the court concerned in the administration of justice, the legal practitioner has an overriding duty to the court, to the standards of the profession, and to the public, which may and often does lead to a conflict with his client's wishes or with what the client thinks are his personal interest. The Honorable Marilyn Warren AC, at a judicial conference in an Australian colloquium, elaborated on this duty and stated, the duty to the court, the lawyer's duty to the court is an incident of the lawyer's duty to the proper administration of justice. This duty arises as a result of the position of the legal practitioner as an officer of the court and an integral participant in the administration of justice. The practitioner's role is not merely to push his or her client's interests in the adversarial process. Rather, the practitioner has a duty to assist the court in the doing of justice according to law. The duty requires that lawyers act with honesty, candor, and competence, exercise independent judgment in the conduct of the case, and not engage in conduct that is an abuse of process. Importantly, lawyers must not mislead the court and must be frank in their responses and disclosures to it. In short, lawyers must do what they can to ensure that the law is applied correctly to the case. You know, nowadays, when a legal practitioner stands up and say, "My lady, the papers are in order," I get worried, what did I miss? Because we unfortunately cannot rely on that submission, because it's seldom that people will stand up and say, "Despite these deficiencies, my lady, but I still move for this order." What is wrong with that? There is nothing wrong with that. But it just shows that if you stand up and say that, then I can rely on you. You make our lives a little easier. And I think this week, I'm saying it for the second time, we are short-staffed. The DG knows I write to his department almost every month to ask for additional acting appointments, because there are just not enough judges. Better prepared, honest, and diligent lawyers are of great assistance to the bench. But I think let me just come closer to home and not really quote overseas people. In our courts, it was succinctly stated in Chetty versus Perumal that legal practitioners tend to forget for a moment that they are officers of the court and that their ultimate duty is to the court and no one else. It is perhaps convenient at this juncture to remind legal representatives of this duty and their role in the proper administration of justice. Advocates and attorneys, when they appear in court, both have a duty, irrespective of whether it is the High Court or Magistrates Court. They have a duty to be respectful towards all role players, especially the presiding officer. Perhaps it is apt to quote what was said in S versus Catuccello and another, 2019 1 SACR 480 LT. Even though the reference is advocate, it equally applies to attorneys. The words used by counsel were both unnecessary, and this is what the court said, and unfortunate. They demonstrated acute lack of respect for the court and its role in the administration of justice. Judges and magistrates alike have been entrusted with the most difficult job to find the truth and administer justice between men and women, and men alike. They are fallible like all others, and in recognition of this weakness, there is a hierarchy of courts so that mistakes can be corrected on appeal or review. It does not serve any purpose for a practitioner to be theoretical and make demands which he knows the court is not in a position to accede to. The ethics of the legal profession say an advocate is an officer of the court. As an officer of the court, he is required to assist the court in the administration of justice. Inasmuch as counsel has a duty to advance his or her client's interests with zeal, vigor, and determination, he should always remember that his primary duty to the court, he should always remember that his primary duty is to the court. His role is in court is not only to push his or her client's interests in the adversarial process, as I have said. Should always maintain the decorum of the court and protect its legitimacy in the eyes of the public so that its confidence is not eroded in their eyes. And I want to quote what my colleague Sigo Binjay said in his article, Restoring Dignity to Our Courts. And he said the duties of legal practitioners in terms of their paramount duty as officers to the court are to conduct themselves with the highest degree of integrity and honesty at all times, to ensure that the dignity and decorum of the court is maintained, and to remember at all times that their first duty is to the court and to no one else. The effective functioning of our courts and the proper administration of justice are highly dependent on how legal practitioners go about discharging this duty. Sadly, the paramountcy of the duty to the court appears to be lost on many legal practitioners of late. The Constitutional Court, with specific reference to attorneys in South African Liquidators Traders Association versus Chairperson Gauteng Liquor Board, stated that an attorney is an officer of the court and owes a court an appropriate level of professionalism and courtesy. The list goes on, ladies and gentlemen, and I don't want to really take much of your time. But the point I'm trying to make, let this be a turning of the tide. Let us go back to basic. Let us respect the courts. Let us respect the presiding officers. That you think I'm so young and you're thinking about your own things as you're addressing me, it's neither here nor there. The fact of the matter is I'm a judge and I'm supposed to pronounce on your case. And sometimes judges react differently to everything that happens. And I said to one of the colleagues yesterday, because nowadays people think that they can just walk into the judge president's office and demand to see her because they want a preference in their matter. So my registrar says, have you complied with the practice directives? And this is yesterday. And the advocate, who's senior counsel, says, no, but we need to make our case to her. And she says, no, you won't see her because you need to have complied. And see, he says to her, your no is not sufficient. Go to her. And she comes, and I say, go back to him and tell him your no is sufficient when he has not complied with the practice directives of this division. And I can't tell you what he said outside, which I know of. So even if I wanted to do a favor, which I'm not allowed to do because we don't do favors, but I won't do it because of that disrespect. I won't do it because of what he, as a senior counsel, is teaching my registrar and the attorneys that were accompanying him to come to my chambers. And most attorneys these days, they let their article clerk writing to the judge president. I'm thinking, oh my word, is it because it's Toba Poyo Dlwati? Maybe if it was a Fandemeve, or maybe it was a Pillay, I don't know. And maybe it was a Williamson, maybe it would be different, but because it's Toba, every Tom, Dick, and Harry can write. It's not going to happen, not in this division, not in KwaZulu-Natal. And that brings me to the next issue. And that brings me, I think unfortunately for lawyers, DG, they don't know that I am the first born girl in my home. And that makes me what Umamura Mukhaha will say is a Rakhadi in my home, and in the Eastern Cape we call them Utatobao. It's simply an aunt, but in the African tradition it's very important because you are responsible to set the ground rules for your family and you ought to lead by example. And if they treat me like that, those senior counsels, all that Dadobao stuff just comes back, and when it starts, you just cannot control it. That brings me to the next item, which is the practice directives. They are, as was reiterated by the Supreme Court of Appeal, practice directives provide essential guidance for the daily functionings of the courts. Practice directives may not derogate from legislation, the common law, or rules of court that have obligatory force. A statute that permits the use of a procedure so as to make its enforcement effective must be adhered to. The competence of the courts to give practice directive is an important means by which the work of the courts may be carried out. However, practice directives must facilitate what a statute requires. Practice directives should not place obstacles in the way of achieving the object of a statute. Practice Directive 1 of the Practice Manual for the KwaZulu-Natal Division of the High Court expands on what the SCA has stated as follows. And it starts with a question: what is meant by the Practice Directive of the court? And the answer is this deals essentially with the daily functioning of the courts. It sets forth how we in KZN do things, Obviously, it does not seek to override the rules of court, which of course have the force of law. Practice directions supplement the rules. They are intended to act as a ruling in advance, as it were, by all the judges of the division as to how they expect things to be done and what is expected of practitioners. Judges are, however, not bound by practice directives. While we obviously strive to achieve uniformity, it must be clearly understood that these directives cannot fetter the exercise of a judge's discretion, and in an appropriate case, he/she may be persuaded to relax or change a practice of that division. In the Northwest, the court provided the following explicit warning against disregarding the practice directive of the division. The time has now come to send a stern warning to practitioners appearing in this division that unless there are justifiable circumstances warranting condonation for the omission or default, courts will not tolerate non-compliance with the rules of court and practice directives. Rules are made to regulate and facilitate speedy preparation by the judges and parties themselves, thereby enhancing the speedy resolution of dispute and minimizing costs attendant to the perusal. The importance of compliance with these directives and rules cannot be overstated. Failure to adhere to these guidelines not only hampers the smooth functioning of the court, but also undermines the integrity of the judicial process. It can result in unnecessary delays, confusion, and prejudice to the parties involved in a case. Also, Gauteng has said that the practice directives make the requirements of the rule more realistic and workable. Its rationale is to prevent the clogging of the court rolls by matters which are not ripe for hearing. And the SCA and the Constitutional Court has also pronounced. Therefore, I believe it is important that legal practitioners are aware of the practices of each of the division of the High Court and that these practices are followed. The High Courts, by drafting practice directives, have seen the need to regulate certain proceedings, not to frustrate litigants, but promote access to justice and the audi altram partem rule. The practice directives generally provide procedural steps that need to be satisfied so that matters may be heard without unnecessary delay. Often, practice directives govern the filing of documents, and the reason for this is to ensure that all necessary procedural steps have been completed and that all documents relevant to the matter before the court are before the judges so that the matter may be heard without delay. You know, we all know we have backlogs in our courts, particularly in opposed matters, and therefore we are inundated with requests for preference. But things have really turned around, and they need to turn around back. Because nowadays, you do give these preference dates, and lawyers are not available, and they tell you, we can hear it, we can come before you on this particular date. And I'm like, since when do lawyers dictate to the judges as to when? So we really have to turn the tide, and I think this generation of lawyers can do that. Don't be shy to tell me if I'm speaking for too long. The other issue that I wanted to touch on was that we recently had a meeting in the heads of courts, and the Chief Justice advised us, or at least expressed his disappointment, especially as to what he sees on television on a daily basis in terms of robbing by the legal practitioners, but also we brought it to his attention, but we said sometimes even the magistrates. And therefore, in our division, we've consulted with the Legal Practice Council and the various stakeholders, and currently I am in a process of drafting a practice directive that will regulate the robbing in the magistrates court. And the gist of it is that everyone will be required to rob in the magistrates court, from advocates to attorneys, and also the magistrates themselves, and we will be very specific, because even the candidate attorneys, I mean, we all knew, when you go to court, you wear something dark, but nowadays you get pink and yellow and whatever other color. So that is also in the process of coming. I also want to encourage the attorneys or the Law Society of South Africa to encourage its members to tap into mediation, because it's something that many of us, particularly in the heads of court, want to move towards, because we believe that it can assist in alleviating the backlogs in our roles. And we are advocating for court-annexed mediation. I know that the Law Reform Commission, the Rules Board, are working tirelessly to ensure that the rules are amended and to ensure that mediation can become compulsory in certain matters. And those will include family law, RAF, and probably medical negligence matters. So I encourage you to skill and equip yourselves and ensure that you are ready when that happens. As I conclude, Madam President, I want always like to quote, in fact, I wanted to touch on the AI, but I know that it is on the agenda for discussion, but all maybe that I can say on the subject of AI is that it does have the ability to bring positive change to society and how things are dealt with, and if correctly used, can be a great support to any practice. And I know, as I said, it will be dealt with. But some of these positives include e-discovery software tools that assist in reviewing documents, software that is able to review a contract or document for potential flaws in drafting and complete repetitive tasks such as filing of digitized document. But I think if we are always well equipped as legal practitioners, we might not have to use AI so much, because also it will take away a chunk of your fees, something which is very dear to any practitioner's heart. And that's why Mr. Mabunda and Mr. Hadebe are resisting from moving from the profession to other areas because of all those nice fees. So as I end, and with my plea that you have heard, I like to quote on a Chinese proverb, which I believe is apt to say. And it says, the best time to plant a tree was 20 years ago. The second best time is now. And I applaud you to make that second opportunity and turn the tide around. Thank you, and thank you for inviting me.
Colleagues, can we rise as we thank the JP? Thank you so much, JP, for taking us back to grassroots and taking us back to school. I think as practitioners, we have forgotten ethics and court decorum, and that has the potential of affecting the public's confidence in the judiciary, the public's confidence in legal practitioners. So we should ensure that by all times we uphold the highest standard of court decorum. Better prepared, honest, and diligent lawyers are very fundamental to case flow management in the courts, and complying with court directives also assist the JPs in managing case flow in the courts. Without wasting any further time, colleagues, allow me to call our next speaker, who is the Master of the High Court in Durban, Edric Pasco. You are welcome, sir.
Good day. Judge President Poya Dlwati, President of the LSSA, Masipa, Director General of the Department of Justice, Advocate Mashabane, Judge Desai, Advocate Myberg, and our Acting Chief Master, Advocate Matibi. Ladies and gentlemen, sorry, modern technology, let's see if this works. Can I suggest that you operate it, because it looks as though the distance is too far? I'm just going to give a short presentation myself, and then we will move on to the online deceased estate presentation, which will be done by the acting chief master. If we can move the slide, please. No, one back. Thank you. This is just a breakdown of who we are as the masters, or the family law services branch. We have a chief directorate with the chief master heading the whole branch. We have a policy strategy section. We have the family advocates, which you're all aware of. And then we have the masters in operational environment. We have 16 masters officers countrywide. And they are dealing with the aspects of deceased estates. Okay. Curatorships operations, the Guardians Fund operations, trust operations, and of course insolvencies and liquidations, which you're all aware of. Complaints by attorneys. We needed to touch on this because at the moment we are getting and receiving complaints directly through to as far as the minister's office without it actually having been gone through the master's office that the complaint originates out of. So as far as the office of the chief master is concerned, we have now developed a complaints register, and when it comes to the escalation of those, we ask you to please deal through the protocols which I will give you just now. All masters' offices, however, have a protocol for lodging complaints, but we are still finding that many complaints are being escalated to the office of the Chief Master Ministry and even the Presidency without having been escalated, as I said before. The protocols are: contact the estate controller that deals with the estate first. Should you then not receive any joy within 15 working days, which is our standard turnaround time to deal with correspondence and or queries that are raised, you then are to please deal with the assistant master that is then responsible for that file or manages the file and is the supervisor of that particular estate controller. Failure to respond in time by the assistant master, and timeliest response there, we're looking at please not more than 5 days, but not less than 1 day. Give the assistant master at least a chance to respond. Failure to respond, you then can contact the deputy master, and of course again without not receiving a reasonable response, you can then move on to escalating it directly to the master of that office. Should the master not give you a satisfactory answer, you are then entitled to lodge your complaint then directly with the office of the chief master, and you will find on our web page the contact details and the protocols for lodging a complaint with the office of the chief master. I just wanted to quickly touch also on a burning matter with regard to fraud. We have picked it up here in KwaZulu-Natal. I do not know if it is happening in other provinces, but I wanted to highlight this to you, to please be aware, and especially within your conveyancing departments, that we are experiencing a large number of fraudulent letters of executorship, and these relate to letters of executorship that have been issued prior to our QR-coded variant, where the letters of executorship have been signed. And these are being used at the deeds office to transfer immovable property. In 1 month, I've had 15 counts of fraud where properties were transferred 15 complaints. Of those 15 complaints that I received, one was actually a legitimate transfer. The other 14 were fraudulent transfers. So please be very much aware of the old letters of executorship. If you have any doubt, please contact the master's office that is responsible to verify that particular letter of appointment. We will gladly do so for you. You can email the master of that particular office and ask that those letters of executorship and or letters of authority be verified. Of course, to counter this fraud, we have now introduced, and not only this type of fraud, but we have introduced the QR code system. You will see all our new letters of appointment have a QR code in the top right-hand corner, and they are no longer signed. You can then verify that QR code directly with a QR code scanner or your cell phone, and it links you directly to the Department of Justice and will tell you that that is or is not a valid letter of appointment. I'd like now to introduce you to our current acting Chief Master, Advocate Matibi. Just a quick introductory to Advocate Matibi. Matibi has come from SARS environment, and we are glad and grateful to have her in our department. What we are now going to discuss is the online system, and I must say, since 2007, when I first became involved in the Masters, what we now call ICMS, we have been hoping and pushing for this online system since that time. 3 years ago, with the help of the previous Chief Master, started the process, and I must say, since Advocate Matibi has joined the department, it has now taken off and it is growing legs faster than any man can wish for. So thank you to her, but please listen attentively to Advocate Matibi.
Good afternoon. I think before I speak of the journey of the deceased estates online, it is important that I explain what the duty or the mandate of the Master's Office is, and also in relation to you, what are we supposed to do? What are we duty-bound to do? So the role of the Master, or the mandate of the Master of the High Court, is to provide efficient, cost-effective, and specialized services of supervision, custodianship, arbitration, and information provision regarding deceased estates, insolvent estates, and trusts. Further, and in relation to you, we have a duty to serve estate practitioners, legal practitioners in the service of estates and trusts, beneficiaries of estates, and minors and mentally challenged persons in South Africa for the purpose of safeguarding those beneficiaries' financial and proprietary rights. Now, that is the mandate of the Masters, and some of you might have had challenges in dealing with us. A few years ago, there were a lot of complaints, specifically during COVID time, regarding the issuing of appointments, letters of executorship or authority in deceased estates. And 90% of our complaints emanated from deceased estates or from the Guardians Fund. And it is on that premise that we actually decided to go on a journey. Can I have the presentation on, please? To embark on a journey to modernize deceased estates. And this has been the journey so far. Pre-February 2023, the Master of the High Court was beset with a lot of challenges, as I've said. Long queues, unreliable and slow systems, loss or misplacement of client records, poor infrastructure, load shedding, which affects everybody, as well as backlogs. Now, it is on that premise that we decided to modernize deceased estates specifically, because most of the complaints emanated from that. We started the initial design in February 2023. We piloted in March with the assistance of BASA through F&B in Johannesburg. And we then moved to Durban, and we piloted right here in Umhlanga. We then moved to Cape Town, but the difference in Cape Town is where we had members of FISA, members of BASA, testing with legal practitioners in Johannesburg and in Durban. In Cape Town, we then included members of the public that would report estates on their own without the assistance of legal practitioners. The minister launched the system in 5 masters' offices on the 10th of October 2023. Johannesburg, Cape Town, Durban, Pretoria, and Thohoyandou were added. Thohoyandou specifically because of the challenges that they've been having in dealing with the numbers that were coming to the office. And we then launched on the a national rollout on the 14th of December 2023, which brings me to the next report. The LSSA reported us to Parliament in October 2023, and they presented challenges, Madam President, that you had with the Master of the High Court. And in that reporting in November, we were called as the department DG to come and respond to the issues that were raised by the LSSA. We made certain commitments, and we said we will introduce interventions that will close the gaps or that would address the issues that had been raised by the LSSA. The first intervention then was we would roll out the deceased estates online to curb fraud, corruption, to curb the late issuing or the non-issuing of letters of authority, mainly in just to the appointment stage. And we made a commitment in Parliament to the LS and to the LSSA that we would implement it by January 2024, and we did it earlier than that. Very muted, I'll accept it. So what still plagues us in that space? All individuals, beneficiaries, deceased individuals are validated against the National Population Register with the Department of Home Affairs. We do this to ensure that the person that is standing in front of us is indeed a beneficiary or that the deceased is indeed dead, because there are times where live people have been reported dead. Now, in the absence of that validation, we are unable to continue with that reporting of that estate, and it is extremely crucial. We don't just validate the deceased, but we also validate the association that the deceased had, that is the next of kin, children, spouses. So that link has been unstable for a very long time. Just this week, Mr. Pasco, we have not had a stable link to the DHA, and that obviously creates backlogs in our offices. This is not an excuse, it is just to let you know what are the challenges in our office. So when we implemented that system now on the 14th of December 2024, I'm sharing with you the usage report across all masters' offices, keeping in mind that some offices have only just rolled out for 3 months, bar Johannesburg, Cape Town, and Durban. So in terms of user registration, since we have launched, this is as at the 15th of April, which was Monday. We've had 8,173 user registrations on the system. However, 2,185 are still incomplete. The user is still deciding whether to complete it or not. Those that are waiting email verification, and you will see those that are waiting DHA verification as well. But completed, we've got just shy of 6,000. In terms of applications, we've had a total of 4,509,000 applications on the online platform. These are 4,500 people that would have been standing in a queue in the master's office. And I think if we were to line them up outside, it would be a very, very long queue. So these are the stats that we have. And in terms of performance per office, or there was a big uptake in Cape Town, and now Johannesburg has surpassed that. But to show that we've gone across the whole country, you would see the lowest numbers in Mthatha. And this is not because the office is not working. It is obviously attorneys as well as clients in that area not using the system, and that is where our encouragement to legal practitioners is that use the system and encourage your clients also to register on the system and submit or lodge their estates on the system. There are many benefits. The rework, what is a rework? One of the complaints, Madam President, that was lodged with Parliament regarding the masters was we do not communicate directly with legal practitioners if there are outstanding requirements that have not been met. Now, with the rework, we are immediately communicating via email with legal practitioners as well as ordinary members of the public about missing requirements. Now, as at Monday, there are 304 reworks. A rework means you have not met all the requirements. Now, the masters asked me as I came here today to say, please speak to the legal practitioners who are not compliant when we ask them to submit requirements, or they would say your response or your no is not sufficient, as the Judge President has said. So if I could appeal, the rework means that our staff have to redo. I think for an ordinary member of the public, it is understandable that they're not specialists in that area, and therefore we would assist them in telling them what requirements are missing. But from Cape Town, the submission is from legal practitioners, we would actually send them 5 reworks on the same matter where they failed to comply. Now, on the negative side, on our side, we reported, Madam President, in Parliament that we were going to revise the turnaround time from 21 days to 15 days from the 1st of April 2024, and we've done exactly that. So what you see on my right, I don't know whether it's your left or your right, but on my right you see where we have exceeded the 15 days, and you would see where the big issues are. Big issues would be in Johannesburg. This is now where the master needs to act, and they have not acted, or they've not issued that letter of authority or executorship within 15 days. And the biggest problem lies in Cape Town, as some of your members would know. But on the good side, we have now issued a total of 2,627, and as I looked this morning, we were over 3,000 in issuing those letters online. These were done in the comfort of people's homes, in their offices. They never had to visit us, except where you need to lodge an original will. The other intervention we promised you was that we will conduct education outreach programs on master services. And we held we actually published training or videos on our portal on YouTube in terms of how the online system works. You can find them easily on those links. And we will conduct community outreach programs as well as assist the Compensation Commission on deceased ex-mine workers that are eligible to compensation for silicosis and other diseases. We also promised that we will increase engagements with stakeholders, and which included FISA, BASA, the LSSA, and the LPC. We had a webinar on the 23rd of January. 2,308 legal practitioners, fiduciary professionals, and accountants joined that webinar. And lots of questions were raised and we answered them. The webinar is available on that, on the Justice portal, Department's portal. And we had an engagement with the LPC just 2 weeks ago regarding our relationship going forward, compliance of legal practitioners to some of the master's requirements and how we deal with it. And the regional directors were there, as well as the head of risk and compliance, and we agreed that going forward there would be an MOU between ourselves and the LPC. But we also agreed that we would reconvene a central stakeholder engagement forum on a monthly basis, and the proposal is that the LSSA must represent the bodies or entities that form part, that are their members. Lastly, on my slide is that we agreed that we will accept assistance from legal practitioners in dealing with backlogs. Now, in that regard, we have agreed that we'll draft a memorandum of understanding between the masters as well as the LSSA and Legal Practice Council, where we agree to accept this assistance from candidate attorneys for a specified period that would then be agreed between ourselves and yourself. And however, we do realize that there are issues of conflict of interest that may arise, issues of confidentiality, as well as improper solicitation of clients by attorneys, which some masters have said they've experienced before. And to that end, we want to draft a non-disclosure agreement between ourselves and the people that would then be seconded to the master's office. And we would want to pilot that in 2 offices and see the feasibility and viability of that solution before we proceed on a nationwide implementation. And with that, I would like to thank you.
Thank you so much to Mr. Pasco and the acting chief master. I think it is comforting to hear that assistance that we've been offering for a long time is finally being accepted after being reported to the Parliamentary Portfolio Committee. I was leading that team that was reporting you, acting chief master, but I'm glad it gave us results. Our next speaker is Judge Desai. Colleagues, please allow me and please rise to welcome Judge Desai to give us a message of support. He was appointed as the Legal Services Ombudsman for a period of 7 years, and he has been continuously involved in the legal profession as an attorney, as an advocate, and as a judge for a period of over 44 years. And he remains committed to the ideals and advanced and crystallized in the struggle years. Ladies and gentlemen, please welcome Judge Desai.
Thank you for that very kind reception, Madam President. And thank you very much to the Judge President of KZN, Judge President Poyo Dilwati. Welcome for the warm welcome to KZN. And good to see you again, Doc Mishabane, the Director General of Justice. Let me recognize also the President of the Legal Practice Council, my good friend, as she says, Janine Myberg, and all of you, friends and comrades, thank you very much for being here today to listen to me. Let me start off by saying this. When I got a call from the President's office to say that they wanted to appoint me as the first ombud for the legal profession. I wasn't quite sure what the job entailed. More than that, I knew it was going to be a challenging job. I knew it was going to be an interesting job. What I didn't know was there was going to be a dangerous job. Not so long, about 2 months ago, a complainant came to us. It didn't come to me, my staff did, my attorneys on my staff deal with it. And one of my staff members dealt with it. They wrote to the LPC gave a response. It was clearly a meritless complaint. No merit whatsoever in the complaint. The next thing that happened, I get a telephone call, and my registrar, my secretary now, phones me and says, "Look here, this gentleman insisting on speaking to you." And I said, "Look here, let me have a look at the file. It's perfectly well dealt with. There's no merit in anything whatsoever." So when he called, I told him there's no, and he started swearing at me. Eventually, he threatened to have me arrested for corruption. He said I knew the attorney, I didn't know the attorney from a bar of soap. And then the next thing that happened is, I get the messenger coming from the Commander-in-Chief, the EFF. He laid a complaint with them that I was a corrupt ombud. And that's where it has ended so far. So I don't know how far it's going to go. But it's become a dangerous job. Let me start off on the merits of what I wanted to say. Janine was quite right when she mentioned the amount of complaints that are emanating against attorneys and the increase in the number of complaints. The problem is the manner in which the complaints are dealt with. I'm not entirely satisfied now that I've been the ombud for 2 years that the complaints are being expeditiously dealt with. I'm not accusing anybody of tardiness, but surely there must be a quicker way of dealing with these complaints than it's being dealt with now. Because those against whom complaints are lodged are frequently attorneys who are offending and who are offending seriously. The new tactic now, as I see in the Western Cape, if a judge lodges a complaint, they subpoena the judge to give evidence. So far, 2 judges have been subpoenaed to give evidence at disciplinary hearings. Firstly, the judges don't have time to sit in disciplinary hearings giving evidence. Secondly, it's most unbecoming for the judge to be cross-examined because somebody misbehaved in his court. And thirdly, it drags out the proceeding. It's Stalingrad in a new way. And these are not people who have just committed minor offenses. These are people who have committed serious, on the face of it, very, very serious offenses, and are often dealing millions of rand. And that delays, the proceedings are not complete yet. I wrote to the Chief Justice of the country, and I asked that we meet to discuss this, but we haven't met yet. So something must be done about that. Judges giving evidence, the tardiness in the manner in which these complaints are processed, and as it goes along. That's on a pessimistic note. The other note that gives some concern for alarm is Janine, I must say, you said I'm your best friend, but I must note this, that not all of the LPC are implementing the Act as it stands. You know, the 2 judges of the Cape High Court correctly found, or correctly quoted Janine as saying, the Section 41 procedure had not come into operation. But they were hopelessly wrong. Janine's affidavit was signed in 2021. The matter was heard 2 years later, 2024. And last year, in May, the Section 41 came into operation. The judges went at length about how the tardiness on the part of the Department of Justice is not implementing the section. They didn't know that the section had already been implemented for 1 year. But the fact that it's not known is that not few people are exercising the rights of appeal that Section 41 contains. That's the one problem. The other is that insofar as Section 41 is concerned, the involvement of lay people is not being used either extensively or at all. You're using 3 people, but one is meant to be a lay. If you don't like it, it may well be so, but then you must approach the government of the Republic of South Africa to change the legislation. As the legislation stands, to give effect to democracy in the ordinary sense of the word, lay people form part of the investigation. So, Ms. Myburgh, I'm your good friend, but please, the failure to implement sections of the Act give rise to concern. There are other sections of the Act which are also not being properly implemented. We must look at it in a way that, not in a way that disrupts the process or diminishes the processes of the LPC, but in a way that creates justice in a sense that was envisaged by the drafters of this Act. You must remember that when this Act was first introduced, I remember Krish Govender being there, I was there, and enormous amount of debating that went into place before the Act came into being. It's a product of a democratic process and a democratic thinking that led to the creation of this Act and the establishment of the LPC. There is, of course, the more optimistic part of things or events that are occurring. Firstly, there's the case pending with regard to the legal sector code. I know that not everybody is happy with the legal sector code, but the legal sector code was approved by the legal profession and is approved by the Department of Justice. It lay on the desk of Minister Ibrahim Patel, the Minister of Public Enterprises, for almost a year. All he had to do was look at it, check the law, whatever it was, and send it on to Parliament. He has not done so, and action is pending to compel him to do so. He's a thoroughly decent chap, but he's a bit of a chap who would look through every line of every document. And his position is that it may be unconstitutional, the legal sector code. But to my own mind, whether it's unconstitutional or not, it's properly presented, and its constitutionality must be determined by the appropriate forum, whether it be the Constitutional Court or lower court. It must be properly ventilated and decided upon. But the exciting thing is this, that it is happening, that the case is pending, replying paper is about to be filed, and that will be dealt with soon. The other is the other contentious aspect. That is the code set up by the Solicitor General. That is a massive aid to transformation if it can go through. But it's also being held up, and the established bodies, established legal fora, not the LPC, the members of the Bar Council and others are challenging that code that the Solicitor General has set up. Now, these are issues that will be ventilated in the court soon, and the outcome of these cases will dramatically affect transformation in the courts, in the legal profession, and to practice. It is my function as Ombudsman to ensure that the diversity of the country permeates the legal profession at every level. And I would welcome the debate that would take place and a favorable outcome in favor of the people of this legal practitioners and in that sense. We do not receive that many complaints. We get about 30 a month. We've done outreach, and most of the complaints, I must say, emanate not from lay people, but from attorneys. Attorneys complaining about attorneys, or lay people complaining about their own attorney. But not many are people, poor people in the countryside of this, in the countryside or in not rural areas that take up complaints against the attorneys. That's where I think most of the abuses occur in this country. What we've done is we go on outreach programs. We went to the Eastern Cape, not the Eastern, what is that area called, up to George, that area we've been up there. We spent a lot of time in Worcester, where we had a large crowd of people attending. And we've also been piggybacking on Mr. Molefe's outreach programs. Mr. Molefe, let me say this publicly, that we're indebted to you. It costs our costs tremendously to just piggyback on what you are doing. But thank you very much for that. So we've engaged in outreach programs. We've also developed new regulations. We publish our regulations, and my staff who are here tell me that I must thank the following people who've actually commented on the regulations and made valuable comments, which were actually incorporated, many of them, not all, but most of the comments were incorporated in the new set of regulations. These are the Bombela Attorneys Association, the LSSA itself, Miles Carter, whoever that is, Kalichi Babunda, the Banking Association of South Africa, and the Bethel of Umhlanga Attorneys. All of these people have taken some care and attention to draft criticism of our regulations, which are now being amended. What we need, as our Judge President said, a new spirit, a reversion to our roots. And our roots is not simply wearing a gown and bowing before a judge. This country came about as a product of enormous struggle and pain on the part of many, in an attempt to create a society which protects and advances the interests of the poor, of those who are the victims of society. And we, as lawyers and as members of the legal profession, have the duty to protect their rights. That's what we envisaged when this act was promulgated. That we create a legal system which is not only representative of the diversity of our country, but it's a legal profession which acts and advances the rights of the most disadvantaged. Ladies and gentlemen, I see I've been given question time. I would welcome any questions anybody wishes to ask. Please do so. Can I just do it myself?
Just 2 questions.
Okay, we have not that much time, but if anybody got an urgent question, please do ask. Is the mic roving mic? Yes, there's a lady over there. Oh, Janine.
Appeal process correctly. If you are of that view, please let me know so that we can investigate it. And I personally agree with you that our process is extensively long. You can fall pregnant, have a baby, and have a toddler before the outcome of your disciplinary matter. But we are restricted to the legislation and the rules. So we would need to amend that, and we would welcome any suggestions to amendments.
Yeah. Now, the legislation seems to be appropriate. I can understand the cost factor, but if you appoint 3 people to investigate, all 3 are attorneys. The costs are the same if one is a layperson, or even less if one is a layperson. I don't understand the process where you're simply appointing the same set of attorneys to your appeal, but I agree with you, the matter can be looked at. The other thing I say this, that what bothers me enormously, the same set of attorneys that do investigations all over the country, the same person who comes, it results in a routine, and it gives a false expertise to what is a mundane matter. All lawyers should know their rules and ethics. But it opens itself to impropriety if it want the way it's being done. I think the last thing one legal profession needs is more impropriety in the allocation of matters to people who hear these disciplinary matters. I think one must look at it in a way that, with great caution, to avoid any, even perceptions of impropriety, to avoid that. I don't know what the position is in all parts of the country, but I've seen things which are most unsettling, which I found most unsettling. We don't want to frown upon our kith and kin as lawyers. We want them to be the examples of, carry the spear that has fallen from a generation of lawyers who are fighters in this country. Think of some of the outstanding sons of the soil, all lawyers. And it's their spear that we carry. Thank you.
Thank you so much, Judge Desai. You have always been a source of guidance and wisdom, and we really appreciate you honoring our invite. And I think, you know, as the LSSA, we'd also like to piggyback on the road shows that you are having as the legal ombuds so that we can also expand our reach, which comes from one of the questions that a member had asked on the virtual platform. Now, colleagues, our next speaker politely asked me not to read his bio. He claims that we all know him in this room, so he said, no, don't read my bio. It is the Director General, Advocate Doc Mashabane, who is also going to give us a presentation. You are welcome, Doc, and thanks for honoring our invite.
Gee, this podium can make one look tall. Eh? Yeah. No. Oh, okay, all right. I see, Madam President, you don't mention that Judge Desai is a veteran of Nadel. I don't know whether it's a taboo to mention things like that at LSSA. But Madam President, thank you very much as a program director. And ladies and gentlemen, I won't do the greetings. I think everyone has been greeted. I greet all of you. I'm told lunch is at 2. So I'm mindful of that. And I have no long presentation to make. I have a speech. But what I'll do, I'll avoid going through the speech and raise some few issues. But I'll let you know what we had in the speech. As an introduction, it's a reflection of the 30 years anniversary of our constitutional democracy, and speaking about the historic context of the evolution of the legal profession. I think what we're trying to do, Madam President, was to look at the theme of your AGM. We're talking about the adoption of the Constitution of the Republic and the issues of the role of women and the empowerment of women in the legal profession. Talking about the single legal profession, the adoption of the Legal Practice Act 2014, talking about the legal sector code. Judge Desai and the other speaker before that have already spoken about it. The work of the Office of the Solicitor General and the policies that we have submitted to Parliament, the issue of the uniform guidelines for conferment of silk and senior attorney status, and the statistics of the general composition of the legal practitioners. Then, of course, we were linking the subject to access to justice and the issue of technology in the justice system. Last week, I was with the Minister at the University of Johannesburg, and one of the law students there asked us a question that with the way technology is developing, artificial intelligence and so on and so forth, is there no risk that lawyers are going to lose their jobs? And then the JP did raise that issue as well. And part of what the minister then said was, of course, the discussion that is going on about the future of work. Because we all know now members of the public can Google any form of contract. They no longer need the lawyers per se. And the reality is that we can bury our heads in the sand and pretend that that's not happening. But part of the real discussion, indeed, Madam President, on the reimagining the future legal profession, things will no longer be the same. I went to see the managing director, the erstwhile managing director of CETA, to talk about modernization of the justice system. So one of the things I told him, which he told me was shocked, I said, I'm willing to have the Department of Justice use as a guinea pig on ChatGPT, to the point that I was saying we need to engage even the Chief Justice, that judges must be allowed to start practicing writing judgments using ChatGPT. And I told my colleagues in the department, all the different segments in the department, including legislative drafting, that it helps no one that you'll spend a whole year trying to use your long hand to draft a legislation, when in fact we can ask ChatGPT and say, we have a problem of abuse of alcohol in this country, we want to regulate it through legislation. ChatGPT will come back and say, you can have a legislation, the preamble can look like this, and these are the provisions that you might have. 80% of the work will have been done. So the legislative drafters will have to focus on making sure that it is context specific. And that's the reality that we are facing. So part of the discussion, I guess, as you continue, you'll have to face that reality and deal with that reality. So over and above the speech, which I'm a former diplomat, will say it will be circulated and it can be published as such without necessarily me reading it. But there are a few issues, about 5 or 6 issues that I want to quickly run through. One, of course, I'll come back to the access to justice issue. The masters issues, of course, I won't say whether I was happy or not happy about you, Madam President, taking us to Parliament. Even if you didn't report us there, it was part of our turnaround plan to change the department. So we're dealing with it. Yesterday, today, and next week, I was telling Judge Desai, we are taking an action against officials of the department that work in masters on the basis of the SIU report. You'll remember in February 2020, we proclaimed, the President proclaimed an investigation into the master's office. I won't talk about whether sadly some of us were complicit or not, but we are taking an action. That's the one part. But the second part, I did write, and I know that we're talking about it with the Madam President here, that the post of the Chief Master had been vacant for more than a year, and I did write to the profession, everyone, I think BLA, NADEL, and AFT, and everyone, and say, look, propose the name of a person who can come and help us. Of course, government, we are doing a service. Can you imagine us who are on permanent pro bono as public servants? We are saving, so there's not much money, but it's decent for one to serve his country or her country. So we have another position of Deputy Chief Master that's vacant as well. So we will still make the call to say that if some of you can take a sabbatical for at least minimum 3 years, I think if you give us 3 years, I still think that that should be enough, then you can come back with the experience. And I think part of what maybe I will have added over and above what the speech will have said about the 30 years will be, we have a constitutional mandate for the administration of justice. But as the JP was saying, the legal profession as well plays a critical role in the administration of justice. Now, if you look at the critical pillars of any successful constitutional democracy, the legal profession and the judiciary generally plays a critical role. So in other words, going forward, the future of our constitutional democracy will depend to a greater extent on how we strengthen the judiciary, but the role of the legal profession is very critical. So all these matters that are being raised about ethics, conduct, decorum, and so on and so forth, it may very well be that if later posterity was to judge us on the future of our constitutional democracy, these may well some of the indicators that will have said things started going wrong when the legal profession started behaving like this and no one spoke out and nothing was done, and ultimately the entire judiciary got undermined. And once the judiciary goes down, you must just know that the entire constitutional democratic project is gone. So I think that part is very critical that we look at. FIC, understand, will be here. So in the justice and security cluster, the issue of the grey listing of South Africa has been raised. We're supposed to go back now in May. In fact, FATF will come to Cape Town, and there are matters that we're supposed to report on. But the role of certain profession and the legal profession has been identified, and we're happy that FIC is here. It will be sad if we continue grey list, to be on the grey list, and part of the problem is said to be the legal profession. In fact, sometimes I wonder, if you look at the days that we're at school and now, whether okay, let me not say it, but the profession remains a noble profession. Now, then the profession must lead by example. Can you imagine you are listed with estate agents? I have no problem. I know they are our wives and our husband and our girlfriends. I have no problem with estate agents. But you are listed with estate agents. So surely that must make you angry, that you must quickly get out of that list. You cannot be anywhere close to any other profession that is being mentioned as being problematic in relation to the Financial Action Task Force. I was saying to the JP, I think I always admired what the former judge president of the Western Cape had done in the Western Cape in terms of the court decorum, that anyone, including the lower courts, it doesn't matter that you are advocates, you have to be robed. So I think my view, actually, I even asked him back then, Judge Lopez, to why are the other divisions not doing it? So part of what we're doing ourselves, in the next 2 months, we will robe all the court interpreters across the country. There's no longer going to be a court interpreter that's going to appear wearing some pink and yellow, ties. We're going to robe all of them. I think so as part of that contribution to the decorum of the court. As part of access to justice, we will convene a national symposium sometimes in July and August, just to have this discussion as part of the 30 years anniversary program. And I think that's very critical. We're grateful that when we invite you to our programs, you are available, but we'll want you in this discussion. There are a few things that we need to look at. The president has assented to the Traditional Courts Act. We are finalizing the regulations. Now, I think we cannot run away from that reality that if you look at our country, we remain a poor country. We're a middle-income country, but we remain poor. Majority of the people still live under traditional leadership in the outskirts and so on and so forth. So that act will assist a great deal in also increasing access to justice. But secondly, we're trying to relook at the small claims court, have some discussions. One of the things that I've been raising, and my aversion to either expanding the monetary jurisdiction is much more low than my colleagues. I was even saying, but if you look at the value of the rent, you look at inflation, I don't understand why the monetary jurisdiction of the small claims court is still sitting at 25,000. I had a meeting in Namibia with the Zambians and the Namibian, I think 4 of the Southern African countries, and I looked at the monetary jurisdiction. In Zimbabwe, they are sitting at 85,000 rands equivalent, and Namibia thereabout as well. So my desire was that at least by this year, we should move it to 100,000. Now, some people came pleading with me that we will shut down the attorney's profession if we do that. You'll guide me, Madam President, but something has to be done. 25,000 is too low. And I think still with the small claims court as well, I think your assistance as a legal profession to assist, the majority of the people in this country. I think the legal profession has a much more greater responsibility than any other profession than we realize it, particularly in terms of the vision of building a constitutional democratic state. So that's one area as well that we will require, you know, your inputs as we move forward. But as for the rest, I think the issues have been covered here. We are making this progress on the masters, and it's a major area of concern, but the level of corruption is a concerning issue. I went to the office in Johannesburg incognito. I just had to wear a cap and wore some jacket. So I moved through the floors and saw what was happening and so on and so forth. Got into some horrific situation of a recorded video of one of our officials who was caught red-handed in, you know, unethical and corrupt activity. So we're gonna deal with that situation, but we require your cooperation. And I know, you know, I used to tell diplomats that, you know, there are no, okay, let not me tell you what I said, but we need your assistance, colleagues. But sometimes the way you come across, and I think sometimes the temptation as well, I fail to differentiate between the touters at that office and the lawyers that were coming in and so on and so forth. So part of what we'll do by next week, I said all the masters officers must have their name tags, and we're gonna get them this jacket that they're gonna differentiate them, so that, and part of what maybe we need to do, acting chief master as well, we must have a discussion with you. The people that you send to those offices, either we agree that we sign, we get you a name tag that will differentiate you from the touters, because they create havoc for us. And part of what now you're gonna see, and Judge Isai was asking me, as you take action and suspend people, what's gonna happen with capacity? I said, sadly, there will be a vacuum. So that's the reality, because some people either are in strategic positions, but we're not gonna let them stay because they're in strategic positions. We'll have to take action. Because otherwise then, you know, of all departments, the department that is called the Department of Justice and Constitutional Development, we can't be associated with all these kinds of shenanigans. Now, finally, my view is 10 years since the Legal Practice Act was adopted. Maybe we need a discussion, Janine, so that we look at all the different sections. So I'm willing, can commit ourselves to arrange and take care of all the logistical related matters, and you bring everyone in, and then we have a discussion so that, you see, to go and amend section 25, well and good, but the problem that you're gonna have is, are you then gonna come back with comprehensive amendments in 8 months of that? So we can quickly work and say, as the new parliament comes in, the 7th parliament, what do we take comprehensively? But part of it as well must include, you know, self-regulating profession, but the Legal Practice Act is managed by the Department of Justice. We need to have a discussion. Where are we now post the Act? Has the Act delivered everything we thought it will? Has fusion happened? What is the future? Is fusion positive? Are we going to walk back? Are we reconsidering, resetting a course? Or we have to look at issues, what are the issues that require legislative intervention or policy intervention in order to take the profession forward? I think there are many assumptions that we have made. Those assumptions may not necessarily have matched up with the reality on the ground. The questions of paralegals, we'll be very much happy to collaborate with you. The department has about 17,000 staff. And of that, there's a big portion of it that goes to people that got hired with matric, to be court interpreters, to be clerks, and so on and so forth. So part of what we're doing, we're relaunching the Justice College, and that's a big program that we are working on doing, which will be NQF level 5. So I think we can cooperate a great deal in this one, because my take is I want all the clerks in the department who are working in courts at least to have a national diploma on paralegal, which, you know, for whatever national qualification framework, NQF level 5 or 6. So it's an area that really will appreciate Madam President, and or you are the outgoing president. Yeah, the outgoing president, and whoever becomes the next president. But as part of your handover, I think you can reflect on that. Thank you very much, ladies and gentlemen.
Thank you so much, DG. I think from the LSSA as the outgoing president, we welcome the proposal for an engagement with all key stakeholders to reflect on the Legal Practice Act. As the LSSA, we are committing that we are available for that engagement. And we also appreciate that the department is also considering or is embracing artificial intelligence. We need a judiciary that is efficient and that is more agile. So it is comforting to see that the DOJ is also embracing the emergence of artificial intelligence. And also lastly, just to encourage practitioners to avail themselves and apply for the positions that have been mentioned by the DG. They have been struggling to find competent candidates to fill those positions, and they are looking at the LSSA and the LPC to assist in terms of filling those positions. And colleagues, I have to apologize, we are running 2 hours behind schedule. But we are at a conference, and if you booked a return flight for today, I judge you harshly, because tomorrow is still another day. So we are going to move into our first session, which is session 1, which is going to be on compliance. We have got Ricardo, who works at Professional Affairs, together with his team. They are going to speak to us on compliance and the role and actions of the legal profession to assist in removing South Africa from the grey list. Can you please assist me in welcoming Ricardo together with his team?
Good afternoon, everyone. Thank you for the invitation, Tony. I must single out that Tony has been one of our fervent supporters since day one. When the FIC launched the legislation, thank you to the Madam Judge President, to my colleague Dr. Mashabani in government, to the Master's Office that is here, to the presidents of these societies. So it's really a pleasure to be part of this engagement today. So briefly, I'm Christopher Milan. I'm a former Treasury official, worked under Minister Manuel, so go back quite some time with the FIC Act. I'm accompanied by Jan Augustijn, who is an advocate, a practitioner, passionate about the profession, and a former secretary to 2 ministers, one of being the late and revered Article Dalla, and then Article Ashley Moy, who is also a FATF assessor and one of our managers, and basically sending you the message on outreach and why we have to do this. So essentially, we have asked to just come and explain, because it's an issue where we hear on a constant basis the unhappiness of the legal practitioners to the issue of why do we have to do this. It's costing us money, and we really don't have the time as practitioners. So we've titled our presentation, Resolving and Exiting Grey Listing by Legal Practitioners. We'll deal with 3 quick issues: that issue, the risk and compliance return, and inspections and enforcement of the FIC Act. But let me take you back to the slide, if you could just put up the second slide, where we talk about the FATF grey list itself. I can assure you that when South Africa was announced as being on the grey list, and when we briefed the President and Cabinet, I'm told, I was not in that meeting, but I was told he was very upset with the fact that South Africa as a country had found itself in that position. And basically he was saying, but this is not us. This is not South Africa. When we recently went back to Cabinet, a few weeks ago to give an update on the FATF report, Cabinet again was very concerned about the lack of the slow progress in dealing with the FATF agenda. And in particular, we were instructed as the FIC, and you need to know this, we were instructed to institute law enforcement action, in other words, administrative sanctions against all non-compliant entities, in particular lawyers. And that comes from the Cabinet, from the President. The understanding is here that what has happened so far and what we have seen happening is that the practitioners have not done enough. It's not good enough. If you could put up the next slide, I'll just show you why, and I'll briefly explain. One of the action items is, and we've got 22 of them, and you will see the 2A. 2A says they use an acronym DNFBPs, Designated Non-Financial Businesses and Professions, including, as Article Dr. Mashabane said, estate agents and lawyers. You heard his comments about the association between the two. But we had always thought, and I'm a former practitioner, I understand exactly what it means to run a business, to bill hours, to be under that constant pressure, and to service clients in the best of your ability. 2A tells South Africa very clearly, and you'll see the May 2024 is the deadline, which means it's now. And as the doc said, we are busy with providing further update to the FATF, and I'm leading the country's initiative in dealing with this grouping, this sector. So we are called upon under 2A to implement and keep up to date supervisory risk tools to identify high risk of lawyers and all the other entities that fall under this broad category of DNFPPs, including estate agents, casinos, dealers in precious metals and stones, trust, service providers, company service providers. And in addition, you see there's a 2B. We are then required to undertake risk-sensitive inspections of a high-risk nature of high-risk entities, but we can only do 2B if we get 2A right. And that is where the big issue is. The big issue is that we have put in place a regulatory tool that requires you to meet certain requests for data, and that is not working. But let me just step back again and just go to the bigger picture. The FATF is a very informed and important institution. There are 40-odd countries. If you go to the next slide, please. And we are required to report to them every 4 months. We have to get out of grey listing by June next year, 2025, because our deadline says our last update report is in January 2025. And that then takes us to if we manage to demonstrate effectiveness in January 2025, we go into the February plenary that will endorse that we've made sufficient progress, and then they will send an international team to South Africa to evaluate and test what we've actually done. And assuming all things being well and going well, if we pass that test in the June plenary of the FATF, we hopefully, and we pray, we will exit grey listing. So that slide just gives you the background. It's too much detail to cover today. I want to show you the next slide. We are making progress, and we're good in making progress with regards to changing regulations and changing laws. We are poor in effectiveness. And that's the issue. The RCR, the Risk and Compliance Return, is an effectiveness measure. It's a measure which enables us to first and foremost Hear from you if you understand your risk as a practitioner or firm of practitioners. And secondly, it enables us then using a risk engine, using your data, to see what the risk tool says based on the answers you have provided. How risky are you in relation to your business? So you will see a lot of greens there, which we are fantastically proud about, right? And that all happened because you will recall we went to Parliament in 2022, and it was one of the most stressful parliamentary procedures because we put through complex legislation in record time, from instruction from the President himself, this needs to be done, and we moved heaven and earth to do so. However, laws and regulatory requirements under the FATF regime is one thing. Effectiveness and your participation is another. We can only be effective if you assist us to be effective, and that, I think, is where we are lacking. So coming back to the picture of the following slide, we often hear legal practitioners complaining, but why are you picking on us? We're just lawyers. We're just advocates. Well, if we put up the next slide, you will see that internationally, and this is not a South African perspective, the world has recognized that the legal practitioners are very vulnerable to abuse, and in fact, in many instances, facilitate the movement of the proceeds of unlawful activities, which means questionable funds. If we go to the next slide, please. I don't know, should I be moving it? Oh my gosh, so I'm the delay. Right, so you'll see the first one here, and this comes out of our October 2021 report. In red, high-risk estate agents and attorneys, unfortunately, even the fact that couples the two of you together, have a poor understanding of risk and obligations, and then AIs generally, and this is a terror financing issue, which is applicable to everyone, understand and mitigate terror financing risk, commensurate with their risk to some extent. Next, you'll see 46, attorneys and other trust and company service providers, estate agents, DPMS, dealers in precious metals and stones, are inherently vulnerable to misuse, abuse. You become the victims of very clever people that have proceeds of crime, and they facilitate that movement through your services. 23, there are other high-risk or materially important sectors underreporting substantially, and you will hear that's another one of the FATF concerns. There is a reluctance to report suspicion and unusual activity. It's not just suspicion, it's unusual commercial activity. Please try and report it. And then the last point is fundamental improvements in supervision is required. So the last comment from me is that, to sum it up, and then my colleagues will come and deal with the remainder slides. If we look at it sort of metaphorically, South Africa and the legal profession is a very, very dark place at the moment. The country is grey listed, and grey listing has cast a very, very big shadow over South Africa, has profound economic effect on our ability and our reputation internationally as a jurisdiction. Secondly, it has cast a very profound shadow and put us in the dark space we don't want to be regarding your profession. What is your profession doing about this? And why is it that when South Africa reports, and I'll be your advocate, so in June, I'm your advocate. I have to go and sit and justify why is South Africa in such a difficult space come June. In fact, we're going to be meeting in May as well. And then we have to justify it purely on the fact. And the fact is that as we sit here, we do not yet have the cooperation nor the willingness, it seems, of the legal practitioners to manage their own reputation. That's the second reputational issue. The reputation of the legal practitioners, domestically and internationally. This has a profound impact. Your counterparts that want to give business to South African lawyers may be very reluctant to do so. just because South Africa is grey listing, and secondly, because they read from the FATF reports that there is seemingly no buy-in, no willingness, no intent to really comply with a legal requirement, which is not very difficult to comply with. It asks you to tell us what your risks are. It's a questionnaire. Ashley will explain how very simple it is to complete it. And then thirdly, there's a third reputational issue, which we face. Because the FATF is very clear. And in our 3 reports which we've given to them so far, they said, oh, we see that your high-risk sectors, as per the report, estate agents and the legal practitioners have not done what they should do. You've asked them to complete this return. Why is it? Oh, we're only at 30% of completion rate. We have now thankfully moved up. We're close to 60 odd, but 60 odd is not good enough, right? Which means 6 out of 10 is doing it, but what's happening to the other 4? And then they say, what are you doing about the other 4, FIC? Do you have powers under the FATF methodology to sanction people that don't comply? And we say, yes, we do. Then what are you doing about it? And that is why you'll see, even the presidency, the LPC has been very supportive of us, as well as the LSSA and Tony and his team. We have had to go very hard in the press about, we need you to help us get out of this situation. We're in this boat together. And I can only argue to the best of the facts before me. I can't justify the unjustifiable or seek to justify what is really not acceptable. So we appeal. This is an appeal call. If you know of colleagues that have not yet done a very simple process of completing the RCR form, please do so, because we really don't want to be in this space where we are your seemingly antagonist, and you view the FIC and the Ministry of Finance and Justice and the Presidency and Cabinet having an issue with the profession. Unfortunately, circumstances are such where Cabinet has even endorsed us. Please take action, because we need this profession to pull itself right, do the right thing, file what is necessary, so we can report properly and with confidence that the legal profession has met its obligations, and please help us get off the grey list. Thank you.
Thank you, Christopher, and afternoon, colleagues. I think it's important to note, if you looked at the previous slide, we were very quick to pull some extracts out of what your industry had done wrong, and quite sneakily, we hadn't done the extracts of what the FIC had failed to do. And I can assure you, we didn't come out of this mutual evaluation process and grey listing process unscathed, and I think we're very aware of that. Krista, you made a remark to say that we're in the boat together, and it's very true, in the sense that you're holding one oar and we're holding the other one, and we can't row together if we don't get your help. In our supervisory response, that response in and of itself is the risk and compliance return. I wouldn't be a regulator if I didn't use an acronym, so we refer to the RCRs. And really, in saying that that is our supervisory response, some of the feedback that we had received is just as much as you do not have an understanding of your risks, we as a regulator and a supervisor do not have a sufficient understanding of where your risks are, and in turn, we don't provide you with sufficient information to assist you in understanding what your risks are. So there really is a knock-on consequence, especially in relation to risk. So what we did then is we had to have a hard look at ourselves. We had to have a look at common practice, what the FATF says, what other countries have been implementing, and we came up with a return. So a return is a questionnaire. It's almost 200 questions. If you have a look at it, it's very similarly structured to the FIC Act in and of itself. So it breaks it up into different core risk areas. So we're looking at client risk, product risk, jurisdiction risk, etc. And these should all be terms that are familiar to you when you're implementing that in practice. And then it also talks to other risks. So what is the specific risk that your entity faces? So what kind of activity within the legal profession are you performing? And that assists us in assessing your risk. So there were 2 directives that were issued. The one that is relevant for your industry is Directive 6. By a show of hands, and I promise I won't tell anyone when I leave, who knows what Directive 6 is about? Okay, so then we definitely came to the right audience today. And I'm hoping by the time you leave, you'll at least click on the links that are provided in the presentation and have a look. Go back and check with your compliance function at your respective industry or in your respective organizations to see if maybe someone has submitted that risk and compliance return for you. So in any ways, Directive 6 is a very specific instruction. It is issued in respect of the FIC Act, which means that it can come with penalties, administrative penalties for non-submission. There was also a Directive 7. You don't have to worry about a Directive 7. That deals with other industries. Now, because you've been a long-serving accountable institution and in respect of the FIC Act, your submission would cover the period from 1 April 2022 to the end of March 2023. Why those dates? It seems a bit odd, but that is our financial year, so it makes life a lot easier for us when we analyze your information, when we put it into our financial reports at the end of our financial year. It was due last year, May. Okay, that's like in a month's time, it's a year overdue, but we've kept it open. Christopher already alluded to the fact that the uptake was very poor. I'll show you some statistics just now. There is still 40-odd% or 30-odd% of legal practitioners that still need to submit their risk and compliance return. It's an online submission. I just wanted to ask, we do have a video. Would it be possible for whoever I don't actually see, I see glasses on someone's head. Would it be possible to play this video for us, please? It's hyperlinked in the presentation. It's only 90 seconds. It's a very short video. And you're more than welcome to, so it's on the previous slide, you're going too far. No, go back. Is that me? There, on this slide. There's a YouTube link at the bottom. It's a YouTube link. Okay, not to worry. There is, these slides, if they can be made available, there is a hyperlink in there. I'll talk through it. I think we've already spent 90 seconds in anyways waiting for the video to come up. But this slide is really just encapsulates what the video is about. There's a perception that the risk and compliance return is onerous. It takes really long to do. Well, if you're looking at the form online and then you have to keep running back to your bank accounts and your financial statements and asking your compliance team, then yes, it is going to take you a long time. Just like if you're doing your tax return, you first go get all of your information and then you sit in front of your computer and then you start capturing your data. There's no difference with the risk and compliance return. We do have a template available of what the online form looks like, so you can print the questions or review the questions so you know what information you need to go and get, and then you can capture it onto the form. So there's the link I mentioned already. It is only an online form. Some people take that annexure, download it, fill it in, and then email it back to us. That's not going to help us. It needs to go, you were talking earlier about the use of AI. We're also trying to make the use of AI so that we can do analytics in the background. And we also have our own risk assessment tool, which Jan will talk about a little bit later. You complete and submit the return, and then you can download a copy of that submission as evidence that you've actually submitted the return. All right, so some important notes, because again, I asked how many people of you knew the directive or that it existed, and if you didn't know that it existed, I can only assume that there was probably not a submission. So when you do go later today, or you do task someone later today to go and check it out, there's just some things that you need to bear in mind, please. Only one RCR can be submitted per org ID number. So there are instances where you might be registered more than once with the FIC. So if you are a legal practitioner, but you also perform trust company and services, you might have dual registration. That means you would have 2 risk and compliance returns that you would need to submit to us based off of that different business. So your clients would be segmented, your income would be segmented. There is also separate RCR submissions for branch networks, and this is, I think, more prominent in your industry where you might have different branches that sits across different provinces. So if you have more than one org ID number with the FIC, and remember that's your registration number with us, you are going to have more than one risk and compliance return. You need to clearly communicate it internally. You need to make sure that you capture your org ID number. Again, I'm just curious, do you guys know what your org ID number is by a show of hands? Okay, that's a better response than the RCRs. It has to be your org ID. It can't be your practice number. It can't be your ID number. Otherwise, it makes it almost impossible. Well, not impossible, but it makes our jobs a lot more difficult when we're analyzing that information to link it to your profile. I already mentioned again, go get your information first, download the document, and then upload it onto our system. All right, so just some very quick statistics, and then I'll hand over to my colleague Jan, and this is to Christopher's point around the progress. So a reminder, 31st of May last year was when your submissions were due. We had a look on the 31st of July, and only 38% of the legal practitioners registered with us, which I think is a very good sample size, had submitted their risk and compliance return. By October, it was 54%, and as of the end of our financial year, so end of last month, was 64%. Now, these numbers look great, but the amount of work, and I think the awesome engagements with the likes of the LSSA and the LPC in trying to reach out, communicate the RCR, really it's a labor of hard effort to get up to 64, and we're not done yet. We still need to get up to a minimum of 90% before the FATF will give us that tick to say, okay, you really have sampled enough within your industry to clearly make a determination on what the risk is for the sector. Then very briefly, I know Christopher had mentioned in passing, one of the other issues of the industry was the very poor numbers in respect of suspicious transaction reporting. I'm actually sorry to say that the numbers have gone down since the report, and this is an area that we really are also trying to push on. If you have a look over our financial years, 2022 was only 306 reports from 16,000 entities registered with us. Yeah, I think the numbers speak for themselves. End of 2023, we saw a slight increase in 505, and then at the end of this financial year, it had dropped down again to 466. So other than the RCR, this becomes a very significant area where we would need to focus joint efforts. All right, that's the end of my story. I'm going to hand over to my colleague, Jan. Thank you.
Good afternoon, everybody. It's nice to see a full house. And first, I just have to compliment and give accolades to the DG and also to Janine Meiburg for your comments on compliance with FICA. Now, I'm the bad guy, you know. Ashley has the nice work. She does the outreach and the awareness, and she chats to people. But my responsibilities are inspections and enforcement. And that's an area of litigation, and generally we don't want to talk about these things. We don't want to say to you, if you don't comply, you're a natural person, there's a 10 million rand fine that you can get. Or if you're a legal entity, there's a 50 million rand fine. But those things need to be said, and we need to understand that non-compliance in this area has serious implications. And we've come a long way, and there was a complaint initially about all these rules that we need to comply with. And now, as an industry, we sit with a whole new attitude and approach. We sit with a risk-based approach. And you need to apply a risk-based approach in the way that you apply the FIC Act. So there's got to be a change in how you view this. And if you don't do it with regulation, this is normally the case, is you go through a process, and it's a long process. The process needs to speed up, and it needs to speed up dramatically, because of the grey list. And I can just echo my executive's comments and Ashley's comments. And you know what? The way that we view it as the FIC is we view you as a partner. You're a partner in this. Christopher has made that comment. You're a partner with us in order to get us off the grey list. You're a partner with us in order to ensure that, that we fight this fight against money laundering and terrorist financing. And if you think that terrorist financing is not applicable in South Africa, you're living in the wrong world. It is most definitely. And FATF made the comment, we don't fully understand as South Africans what our risk to terrorist financing is. So let me come back quickly to the presentation. And I don't want to, let me just see, can we go to the next slide? Can I just, where does it sit? Ah. No, that's the wrong one. That is, that, let me just see. Apologies for that. So, let's just quickly talk about the supervision model. So when you look at this model, you will see that supervision of the FIC Act entails a lot of functions. And inspections and enforcement is only but a small part of it. But the foundation sits really at the bottom with registration, public awareness, and outreach. And that's an area that we are really excellent in. We are really doing a lot of work, a lot of outreach, and we're reporting to FATF on these issues as well. Then we have public compliance communications, and we've got guidance notes that we issue. I really, really want to press upon you that you ensure that you go to our website and that you look at those. There is a wealth of knowledge in those documents. People don't read them. I know. I've been practicing as an advocate. I know what your workload looks like. I know the stress that you are under. All of us have that. We have all the accountable institutions sit with the same obligations. You must make time for it. And you must make time to understand it and to get grips with it. You know, there's a certain lingo. If you're an attorney or whether you're a state agent or whatever business you have, if you can start talking the lingo and you can understand exactly what an RMCP is and RCR is and CDD and CIV and what knows what, then you are getting in the right space. And the more that you get engaged with this, the more you will understand what you don't understand. And there's a lot of things that we don't understand because we don't venture into trying to comply. We need to change that, and dramatically so. Compliance monitoring is a major area that we focus on. It's a softer touch, trying to get institutions to comply, also provide a lot of information, hand-holding. And then inspections, which is conducted in terms of the Act. We have specific provisions. We are well stocked. We have a lot of inspectors, inspection teams, continuously trying to fill positions, to get the right people in. And you will engage with these inspectors. And an inspection by its mere nature is intrusive. But you don't have to fear that. Because our inspectors will initially draft a draft report, which they will submit to you, and get your representations or your input before they issue a final report. We stringently adhere to the Audi Alteram Partem rule. So please engage with inspectors. Do not hold back and be afraid. Engage the inspectors. And we found that there's a lot of value if we have an open relationship. And then lastly, enforcement. So maybe before enforcement, maybe just talk about remedial action, because remedial action is quite important to take note of. Everything that we do where there's no non-compliance is aimed at getting the industry to become compliant. We need that change in compliance behavior. We need that change in compliance behavior. So it may be that you are non-compliant on the issue, and you fix that behavior. That doesn't mean that we cannot take enforcement action. So let me explain this. You're a firm of attorneys, and you were established in 2005. We're now in 2024. If you still, and granted, the RMCP came an obligation in 2017, but if you still don't have an RMCP, a risk management compliance program, and you don't know what it entails, you are in serious trouble. The risk that you have is not only a regulatory risk, it is also a reputational risk. And if you're caught out, don't fix it up and think it's now bygones. That's not going to happen. Because we have to give feedback to FATF on these issues. So please take that in consideration. Okay, so you now know that it is a FATF requirement that inspections must be risk-based. So if you don't provide us with that RCR information, we are unable to conduct inspections on a risk-based approach because we simply don't know where the high-risk institutions sit. That automated tool that we have, the RCRA tool, that tool provides us with that information so that we can concentrate our efforts in the right areas, which is totally in line with what you have to do in respect of your clients, right? You need to understand where the high risk sits so that you can concentrate on those individuals, those persons, and apply a higher customer due diligence to them. So it's so important that we understand that. So, and I don't want to throw too much stats around, but we've conducted 273 inspections last year, 23-24. 137 were specifically on the RCR. Most institutions are not compliant. And our inspections were mainly aimed at Gauteng, Western Cape, and KwaZulu-Natal, but we did inspections all over the country, but the bulk was conducted in those areas. The non-compliance found is quite alarming. So what are the key findings? Well, firstly, some of the businesses, some of the firms of attorneys don't have a business risk assessment. So if you ask me, Jan, what is a business risk assessment? I would say don't ask that question because it's a key fundamental issue. Okay, we're running late. So I'm going to speed it up. It's a key fundamental issue. You need to understand your vulnerability for risk, and you may find, for instance, money laundering. What is your money laundering and terrorist financing risk? If you don't understand that, you won't be able to determine which of your clients are high or medium, low risk. So that's an important area. The RMCP, some institutions simply don't have an RMCP. Other institutions use guidelines, and the guidelines are perfect, but a guideline is simply a guideline. It's not an RMCP. So your RMCP needs to be tailored against your business risk assessment. Apologies. I'm going to try and move a bit faster. So compliant with Directive 6, we only found 43 institutions out of 138. And that's alarming. Just a word quickly on targeted financial sanctions. We conducted 130 inspections on TFS, targeted financial sanctions. And of those institutions, only 26 were found to be compliant. Why I'm mentioning the RMCP and the targeted financial sanctions specifically is because there are key compliance areas that we need to comply with. On enforcement, we need as a country to display that we deliver effective, proportionate and dissuasive sanctions. That is bad news, but we have to demonstrate that. We have issued since November 2023, a total of 302 notices of intention to sanction, and we've issued 9 sanctions on general FICA non-compliance. The largest fine for non-compliance actually went to a firm of attorneys, and the amount was for 7.7 million rand. So you can see we've got teeth. We've got teeth. Yeah, and with that sad note, thank you very much.
Yeah, that's on a sad note, Jan. Okay, so the team has to leave here at 2:30, which gives us 3 minutes basically to ask questions. It's not a lot of time. I see one hand. Please help me, 2. My glasses are messing me up a bit. Okay. Okay, there's a bit of flexibility. So can I please ask you to keep the questions or comments very brief? Thank you, Madam President.
Chair, thank you very much for the presentation. I just have a question. The assessment period, when is the next assessment period? Because surely if you report to FATF, your figures are going to be a year outdated. And I wanted to inform practitioners that you are sanctioning, and the highest I heard was someone phoned me last week that they were sanctioned 285,000, 7.7 million. We haven't heard. So it's important that the profession is aware of that. Even if you do comply, there is ramifications if you had not complied. But the question is basically, your figures are going to be outdated for FATF.
Thank you. Can we have the second question and then get the response? I saw somebody else's hand.
It's going to be hard to be short, but let me just say that, you know, the illicit flow of funds out of Africa is facilitated by big business in Europe and in the West and elsewhere too, East too. And that's very, very hard to prevent, but Africa is at the mercy of powerful agencies. Secondly, now I'm not speaking, I'm all for FATF, and the firms I'm associated with have already complied. But I think we just need to get the global picture. There's also this issue of terrorist financing. Now, you know, we know who is being called a terrorist today. And we know who is the real terrorist that has made people to resort to so-called terrorism in trying to seek justice, self-determination, and freedom. And you know, if Madiba was alive, he would be probably fined and probably imprisoned under FATF. So the global institutions that you have to report to are seriously in need of accounting themselves, and they need to be straightened up to have a just world order. This is why we have to battle at the International Court of Justice to try to get those very same perpetrators of international terrorism to be straightened out. There's a lot more I can say, but thank you, Ricardo.
Was there a third hand? Yes, thank you.
Thank you, everybody. I am Advocate Sogoni from the University of Zululand. I just want to know if your institution can intervene. We have a problem here in South Africa of something called triple BEE. As a clinician, I get complaints from more than 3,000 beneficiaries of triple BEE. And I have escalated this matter with the public protector, and she has since said, no, you don't have to worry about it because this is a matter between private entities, you know, and these companies that have been formed by multinational companies. This is what happens. Multinational companies used an opportunity to say, we are going to make our workers business people, regardless of whether they are uneducated or not. And they have exploited that in saying, even if this program doesn't succeed, we are going to demand incentives from the government because the government is sleeping on its job. It does not do what is called oversight. Whether that system succeeds or not, they still benefit in tax rebates because they are, but this is a program that has 99% failure from 1993 up to today. It carries on. Companies like Coca-Cola, Afrox, SA Breweries have things called owner drivers, and those people are not benefiting anything. Is there anything you can do to circumvent this? Thank you.
Thank you for keeping the questions and comments brief. Can I hand over to the team to respond, and then we can have another round of questions?
Yeah, no, thank you, Professor Sono. Yeah, Soho, yeah. Thank you so much. I would suggest that you get in touch with the Law Society of South Africa for our details, and please send us your memorandum on the issue, and we will see how we can assist you. Because this is probably an intergovernmental issue, but we don't mind taking up the issue on your behalf and evaluating it and referring it within government to the correct body. So we would like to assist you. Thank you so much. On the question that Ms. Meiberg raised, LPC, yes, this is the conundrum that you are so right. This obligation had to be completed by a year ago. And because of the low uptake, we are duty bound to complete the cycle. In the methodology, we cannot go into the next questionnaire if we don't complete the first one. Just makes no sense. So essentially the FATF have said, the country needs to ensure that under action item 2A, using the risk assessment tools, that the profession, and we need to work with the profession until they get up to a number that would be acceptable across the board, and that is what we said. We aspire and we should be getting up to 90%. And only once that is done, we'll close the evaluation questionnaire for this set of questions, and we will probably then go into the next questionnaire, because the methodology requires that we go back to industry on a regular basis with this questionnaire. So this is number one. I can assure you it will be done annually. But because questionnaire number one is taking so long to bed down, we are unable, from a perspective that would meet approval, to go into questionnaire number two. So we've got to first close out questionnaire number one. And yes, we do communicate our sanctions, but because there is an appeal process, we can only communicate and publish them once the appeal process is closed. So that matter which Jan mentioned is under appeal at the moment, and but we publicize wherever we go that we have issued so many sanctions. We obviously don't disclose the name, we don't disclose the province nor the firm, because it's under an appeal process. But the industry needs to know we are taking action. On the very pointed question on terror financing and what is its meaning, well, I only need to refer you to what our president has said on the matter. We have a particular understanding as a country, and we've expressed that. However, we are part of an international, global intergovernmental body where it has 3 pillars of compliance: anti-money laundering, counter-terror financing, and proliferation. And if you look at who is in that 40-odd countries, they are the leading economic countries. And that body was formed decades ago by the G7 to foster economic development and at the same time to fight the crimes that were evident then. So it's very much us. Do we want to be part of the global village? Do we want to be part of the economic development and be our voices being heard in the OECD, the IMF, the meetings of central banks, or do we want to be isolationist and live in our own bubble, and then we find that nobody wants to invest in South Africa? This is, as far as we understand it, why we are doing this is not for the FATF, but for our own benefit. And for our own benefit, we need to ensure that our economy has a reputation so it can attract investment funds. Investment funds are only going to come from places where they have a surplus. South Africa is in a dire need of international funding as part of the global village. And as a lead in the global south, we are in a dire need of international funding. We do not generate enough revenue in South Africa. The Treasury, I'm a former Treasury official, you would see what our debt ratio is. It is because we have so much social development and upliftment to do, it costs rands and cents. So yes, we have our particular views. We also at the same time need to ensure we become an attractive investment jurisdiction for funds that can assist us develop and our people be developed socially, economically. But at the same time, we cannot discount the fact that you as a legal practitioner fraternity have a very important role to play. Grey listing is not a place we want to be. We want to be in the sun. We have to remove the shadow of grey listing, and we can only do it with your cooperation. Thank you.
Thank you. Thank you so much. So that concludes this session. Firstly, thank you to the team from the FIC. I must say, since I've been involved at the LSSA, the FIC has never said no when we ask them to engage with us. So thank you very much. And it's always been constructive. Thank you also for your indulgence.